All right, thanks everybody. And Matt, really appreciate the opportunity to be here to talk about a topic that is near and dear to my heart, but also I think important for a lot of people. My name is Jordan Bush, and I'm an attorney with Alice Law. We are a firm in the Cascade area that really focuses on just a couple of different practice areas. And I'm going to get into that shortly. I want to give you a quick overview of what we're looking at today. We're going to talk about some findings that just came out in an estate planning study, which I think are interesting. Go over some of the basics of some estate plans, tools that we use, and then also have some time for some question and answer. So like I said, we're located in Cascade, and we really focus on estate planning, estate administration, and then some real property transactions as well. Estate planning being typical wills, trusts, powers of attorney, the things that we're really going to cover today. We also do incapacity issues. Those would be guardianships and conservatorships. That's when we're getting the courts involved if somebody has become incapacitated and hasn't been able to execute documents ahead of time. We do elder law, which is planning for long-term care planning, nursing home, Medicaid applications, things like that. And then also estate administration, which primarily is the administration of somebody's estate, whether it's a probate administration or a trust administration, something that happens after somebody passes away, making sure the right people are put into the positions to make decisions on behalf of the estate, and then ultimately distribute assets according to the decedent's will. It's very important for us to stay in those lanes. We don't practice outside of those areas. But if you ever have a legal question and don't know where to go, please feel free to reach out. If it's not us, we're happy to get you in touch with the proper counsel who can help you on all of those matters. But where I wanted to start was so often people, quite frankly, don't have an estate plan, and it's difficult sometimes to get an accurate number because most estate planning documents are not filed anywhere publicly. They're private documents, they're contracts. So we rely often on surveys or things like that to get a good idea of how many people have actually executed documents. A recent survey came out just in 2020 that had three really important findings. The first is that estate planning is becoming less prevalent across the spectrum, regardless of people's age. Less prevalent even over the last couple of years. A large amount of people have not gotten documents done. We're going to talk about that in just a minute. The second finding was that older adults are becoming less likely to have a will, which is one of those critical, fundamental instruments that we use in estate planning. And the last finding was that a growing number of people lack the knowledge and resources to get a will or an estate plan. So when we actually look at the numbers, it looks like you can see those numbers right there. Even from 2017, the numbers are down to approximately 1 out of 3 people saying that they have a will. We typically hear somewhere between 1 in 4 or 1 in 3, so between 25 and 33%, and this would be fairly consistent, have really any level of estate planning documents, and most people start with a will. So if you haven't gotten any estate planning done, just know that you are in the majority of you are like most people. But what was really shocking here was the drastic change over just a 3-year period of time. If we're really looking at 1 in 3 people having a will, some questions pop up and is it a sufficient will? Was it properly done? Are the people that they have in the will still the people that they want acting in those roles? Are the beneficiaries the people that they want? Is the will up to date? So if 1 out of 3 people based on this survey have one, the next question would be how many actually have active or up-to-date documents? Another finding we saw was broken down by age group, and you can see the 18 to 34 group has the fewest amount of people that have actually completed some sort of estate planning documents. And we're going to talk a little bit about how there are different needs at different stages of life, so that that 18 to 34-year-old group, those are our young professionals. Those are our people who are just starting a family. And those people are going to have different needs than somebody who's, say, in the 35 to 54 or the 55 and older group. But as you can see, based on this study, fewer people are actually getting their documents done regardless of the age group. Not only, especially in that 18 to 34 and 35 to 54 groups, a minority of people have actually completed an estate planning document. But the somewhat alarming thing in the 55 age and older is the trend year over year on what percentage of people have actually completed a document. So the question is why? What would stop people from getting estate plans done? The top reasons that we have heard, not only in our practice but also in surveys, are the first one is, I'll eventually get to it. I'll get around to it, or I've been thinking about doing this, for years. Usually, life events, things like having a child, getting married, maybe buying a house or buying a business, something like that. Those life events are usually the things that will eventually cause people to go and get the estate plan done. So often people have said, well, I'll get around to it. It's just not at the top of the priority. The second reasons we often hear is it's really only for the wealthy people, or I really don't have an estate and therefore I don't need an estate plan. Now, regardless of how wealthy you are, and regardless of whether you have a $25 million estate that has estate tax issues, or you're just starting out in college, the appropriate level of planning is necessary for everybody. At our firm, we promise to do three things. The first thing is that you are going to understand your estate plan. And how we do that is we have you come in for a free consultation. We talk about what your goals are, what you have, and then we simply tell you the tools that we have at our disposal to realize your goals. Our second promise is that we're not going to either over plan or under plan. We are going to tailor a plan specifically to accomplish the goals that you've set. And the third promise is that we're going to be transparent in our pricing, which leads to the next reason why people don't get a plan is often people have the presumption that it's too expensive and it's just not something that they want to invest in. Well, our promise is that we're going to tell you exactly what your estate plan costs on the front end. That way you're never surprised by a bill. The last reason that people don't have a plan is they just don't know who to talk to. Maybe their parents had a plan, an attorney, maybe somebody else, but it doesn't feel like they have an attorney who they can talk to. They don't have a resource, and that's why, Matt, I really appreciate opportunities like this to really get our message out there, saying we would like to be the people that they talk to, especially if you have no place to start, you've never done any estate planning. Please feel free to contact us. We're on all the social media platforms, and we'd love to get your questions answered. To take some of the mystery out of estate planning. Now I'm going to get into some of the basic estate planning tools that we use, and we kind of call these the four corners of an estate plan. And we'll break them down with a little bit more detail. But the first is a medical power of attorney with a HIPAA authorization. The second document is a financial power of attorney. The third document is a will. And the fourth instrument is called a trust. Each of them serve a different purpose and achieve a different goal. Often people come in and will kind of convolute all of these different tools as to what they do. Each has a very specific use and a very specific purpose, and that's through our initial make sure that your documents comply with the current state law. Michigan law defines the patient advocate or empowers the patient advocate to exercise powers concerning care, custody, and medical or mental health treatments decisions for the principal being the person who's no longer able to make decisions for themselves. Incapacity, which is often one of the triggering standard for these powers of attorney, can happen in a number of ways. It could be due to an accident. It could be due to an illness, or it could be due to aged and just diminished capacity. Really important to make sure that our medical powers of attorney meet the statutory requirements. A couple of them include it must be in writing, it needs to be signed by the principal, it needs to be signed in front of two witnesses that are not related to the principal. And before the patient advocate can go and act on behalf of the principal, that person must sign an acceptance. Often we see documents that people went out and they did a Google search, or they looked online, or they created their own documentation, and it doesn't meet the Michigan statute for a valid medical power of attorney. The other thing that we often see is the older that a power of attorney is, the less likely that a third-party healthcare provider is going to honor that power of attorney. The reason is if somebody walks in with a 20-year-old medical power of attorney saying, I would like Jane to be my patient advocate, the third-party healthcare provider doesn't know if Jane is still in that person's life. Maybe it's a former spouse. Maybe it's somebody that they've had a falling out with. So age is certainly one of the criteria that we're going to look at when we're looking at a valid, durable medical power of attorney. Along with that, we always include what's called a HIPAA authorization, and that is the principal signing off and telling a third-party healthcare provider that they can release identifiable medical information to the agents that are listed on the HIPAA authorization. There is often a presumption that a family member, such as a spouse or a child, that they're entitled to that information from a third-party healthcare provider. We have a lot of conversations with adults with adult children. For example, if somebody's children are off in college, if those college-age students are above 18 and they get into a car accident or they're in a hospital, parents have the presumption that, oh, I'll be able to speak to their doctors, I'll be able to speak to the professionals at the hospital, and they will release information to me, which is not the case, even on a spouse and child. So we always start with a HIPAA authorization, allowing that release of information along with that durable medical power of attorney. The second tool, once we get that in place, the second tool that I always recommend is a durable financial power of attorney. And this has a very similar function, but it's for a different content. So instead of making medical decision, this is the agent, as designated in the power of attorney, is empowered to make non-medical or financial decisions on behalf of the principal. It too has to be in writing, signed by the principal, signed by two witnesses or a notary, and then a signed acceptance by the agent. Now, where we see this document most often is if somebody is incapacitated, again, due to accident, due to illness, due to age, and they need somebody to pay their bills or manage their assets or perhaps apply for a government benefit, whether with the Social Security Office or with the Department of Health and Human Services. They also, if there's for example, an issue with a tax return with the IRS, these are all things that fall within the scope of an agent under a financial power of attorney. Now, absent this financial power of attorney, if this document hasn't been done and somebody is incapacitated and somebody needs to make decisions for them, we have to open what's called a conservator petition. So we have to go down to the probate court and ask the court to empower somebody called the conservator to make decisions on behalf of the now incapacitated individual. We do that regularly in our practice. We like to avoid that by getting these documentation in place on the front end. It avoids having to go to probate. It saves a lot of time and it saves a lot of money. We also avoid the court requirement of signing off on all of the decisions that a conservator would have to make. So the two powers of attorney, medical and financial, are really where we start from a triage standpoint when we're talking to an individual who doesn't have any estate planning documents. The next document, and probably the most commonly known or commonly discussed, is the will. And I threw this picture on there because people often have this idea that somebody is going to pass away and then they're going to go to an attorney's office and there's going to be the reading of the will, and usually the mystery beneficiary jumps in and ends up taking all the assets from the family. But a will is best summarized as a directional document. It basically says, if I die, here's all of the things that I want to have happen, or here's who I want to to either leave my stuff to, but I'm not there, I'm dead, so I wrote them all down, and I want the probate court to direct the following things. The three big things that a will is going to do: one, it's going to name the personal representative, and that's the person who is administratively responsible for somebody's estate after somebody passes away. The personal representative used to be called the executor of the estate, same thing, same role, just a different title. They're the person who is going to deal with the funeral home. This is the person that is going to deal with the IRS and let the IRS know that the decedent has passed away, and that person's Social Security number, for example, is now retired. They're going to deal with the Social Security Administration office, and if there's a Social Security benefit either going to the person, to the decedent, or to their family, the personal representative is going to assist with that. So I want you to think of the personal rep as the administration of the estate, but only after somebody passes away. The second main thing that a will is going to do is if the decedent had minor children and there weren't any other guardians, they're going to name the guardians within that document. Really, really important point here, and it's something we talk about with all of our clients who have minor children. How we identify the guardians for minor children is critically important. For example, often a husband and wife will come in, and if they have minor kids, they might want to leave it to one of the spouse's sisters, for example. And if the sister is married, so the sister's spouse, we ask, if the sister has predeceased you, would you want your sister's spouse to be the guardian? And sometimes they say yes, and sometimes they say no. Reason I bring that up is we have to be very specific on who the guardians are going to be. If we don't specifically name them in the will, then the probate administration and the court will ultimately decide who the guardians are for minor children. The third thing that a will does, and probably the most commonly asked or common issue, is designates who the beneficiaries are for the assets of the decedent. So it's the infamous "who gets my stuff when I die" question. So the common misconception that we get with a will is somebody will come in and say, I have a will, and when I die, does this mean I get to avoid going through probate administration? And I say, well, unfortunately, your will is your ticket to probate administration. If you are distributing assets via a will, it will go through probate. And then people say, well, what is probate? And it's a great question. So probate administration is simply a very specific court with a very specific purpose. It's held at the county level. So each county has its own probate court. Here in Kent County, Judge Murkowski is the chief judge there. And in a probate administration, you're presenting a request to the court, and at the end of the administration, the court will have reached a conclusion or adjudicate that matter. So if somebody dies with a will, the will gets presented to the probate court. The court looks to see, is it a valid will? Did it meet all the statutory requirements? Is there any reason why we wouldn't honor the wishes in this will? And if there aren't any reason, then they will order the things that the decedent has asked for or directed. The court will order that. This is, however, the opportunity for other evidence to come in, and whether that is a subsequent will, maybe a will that trumped or superseded the will that was presented. This is where the finding of fact happens before an adjudication happens. One of the tools we use to avoid distributing assets via probate administration after somebody passes away is a trust. Trusts are often misconstrued as just, again, a tool for extremely wealthy people. And yes, there are techniques and strategies that we use for people with estate tax issues and those types of things that we utilize trusts for. But typically, a trust is simply a contract. It's just an agreement between the grantors of the trust, the people that created it, and the trustees. The trustees are basically the managers of the trust. They actually are subject to the trust agreement and carrying out the rules of the grantors and the wishes of the grantors for the benefit of the beneficiaries. And just like that name sounds, beneficiaries are people who benefit from assets that are held in trust. There are a variety of different kinds of trusts. There are living trusts while the grantors are alive. There are testamentary trusts that are created upon somebody's death. There are revocable trusts that are changeable during somebody's lifetime, meaning the rules can be changed, assets can be put in and taken out of the trust. There are irrevocable trusts, which once they are created, it's much more difficult to modify. The grantor, the person who's created it, has a lot less control over the assets that are held in those trusts.
And hey, Jordan?
Yeah.
So you talked earlier when you were talking about wills, about the fact that someone might have a will, but then there might be a document or a testament after the fact that they might have given like on their deathbed. Yep. That oftentimes then confuses things. So yep. Are you saying now that with a trust, it's more of a legally binding thing where, someone's saying right before they die something different, it would not affect the trust? How does that work?
Yeah, so assets that are titled into the trust, into the trustee of the trust, more accurately, are subject simply to the rules of those trusts. So unless the trust agreement, the contract between the grantor and the trustee is modified, that's going to be the binding document, so long as the assets are either titled into it during the person's life or they're titled in at somebody's death. And often we will do what are called transfer on death beneficiary designations for things like interests that are held in an LLC or a corporation. We also will deed real property into trusts upon people's death through the use of ladybird deeds. So the trust agreement, as long as it was a valid trust that wasn't executed under duress, is ultimately going to govern the assets that are held in that trust. We recently had somebody contact our office, and there's a dispute over a couple of pieces of real property. The woman who called us claims that she is the sole beneficiary of those two. They were owned by her mother, and she said that a cousin that she's never met has now said that mom executed a will subsequent or after the will that this woman who called us had possession of, claiming that she cut out her daughter and is giving everything to this long lost cousin. So these are where it sounds like it's just coming out of a movie, but these are the issues and fact patterns that we deal with on a regular basis. Ultimately, the last dated, so the last executed will typically starts with all previous wills are null and void, and this is the governing document. However, we then look to see if the will was executed under duress, or if the person executing it, the testator or testatrix, was still had capacity to execute a will, and that's when we'll go to the probate court to see if it's a valid document. But assets, like I said, divvied up via the trust or distributed via a trust are outside of probate administration. It is not part of somebody's probatable estate, which makes it much easier to distribute the assets. It's typically more efficient. You don't need the court to sign off on things, and we're able to distribute assets quicker through a trust administration than we are through a probate administration. Wanted to highlight just a couple of benefits of estate planning, really at any level and at any age. The first is you get to plan for your own needs. So if you get those proper documents in place, starting with the powers of attorney and the will and the trust, you're able to not only manage your assets while you have capacity, but you're able to manage the assets for your own benefit if you become incapacitated. Second benefit is you can provide for your family both now and later without having more involvement with the courts. So providing for your family should you become incapacitated, or leaving assets to your beneficiaries, minor children, after you pass away. Three is if you reduce the burden on those who settle your estate. And by that, I mean, you by creating a clear plan, you're letting people know exactly where you want your things to go and who should be filling those roles. It's amazing how efficiently plans can be administered after somebody's death if a clear plan is laid out. However, we also often see families fighting over things that they would never fight over prior to somebody passing away, simply because there wasn't clarity on the plan. We can minimize tax liability for not only the estate at certain levels, but also minimize tax liability for the beneficiaries who are receiving an inheritance. And then last is asset protection while somebody's alive. If you're in a highly litigious field, if you have a high net worth, there are strategies that we can use to protect your assets from creditors, from divorce, from you losing your family wealth. All of which are important while you're alive, not simply for planning after you're gone. So with that, I'm happy to take any questions generally, or if somebody wants to go through the chat function, I'm happy to answer any questions. I know that was about 2 years worth of law school in about 25 minutes, but hopefully people were able to follow along.
So Jordan, I know when I came into Alice Law a couple of years ago to work on our estate plan for our family, it was a very collaborative process. Is that always the case? Is that what anyone can expect with you guys, with everybody? I mean, I remember you guys had the whiteboard out, and it was almost like a game where you guys laid out every possible eventuality of like bad situations that could happen to us. And it was like, all right, if you die but she doesn't die, what happens to the money? What happens to the kid? What happens to the this? What happens to the that? Then it was, all right, what if you're both alive, but what if you're incapacitated? Is that how it works for everybody? Or could you kind of walk us through what the process looks like when we want to actually meet to do an estate plan these days?
Absolutely. It starts with the initial consult, and we jokingly say that the most efficient high-tech piece of equipment we have is a whiteboard. We'll have you in. We'll whiteboard your life up on the whiteboard. So we'll draw it out. We'll give you a visual display of this is what your family looks like. These are the assets that you have, and these are the goals that we're looking to accomplish with the estate plan. And having that visual certainly helps takes what can be confusing documents or confusing legal theories and just break them down into a very simple picture. We then also talk about the most common contingencies that people deal with as they're working through an estate plan or through their lives. And by spelling that out, people know, okay, even if this and this and this happen, I know my wishes and my goals are going to be accomplished.
Cool. And then another question I got from the audience. So let's say we create an estate plan, a will, a trust with you guys. Where does it exist? Is that filed somewhere, or is it just like, do we need to trust that Jordan is social media stalking us so that when we die, our trust gets inactive? Like, where does it live? Where does it exist? Is there like a big cloud for attorneys? What's the story?
Yeah, great question. So we'll break them down individually. The powers of attorney are simply individual documents. They're basically contracts between the principal and either the patient advocate or the agent. So we will give, when somebody goes through our process, they will leave with a hard copy binder of all of their estate planning documents. We'll also have electronic copies of everything that we send off. So in case the house burns down, we still have copies of all the documentation, and we will retain for safekeeping original signature pages. So we have wedding pages. The trust is again, it's a private contract, so it's not filed anywhere, it's not recorded anywhere. It's simply an internal document, and one of the nice features of that is probate administration or things that go through the probate court are of public record. And so if someone has a concern about privacy at all, utilizing the trust as a private document that doesn't go through probate administration will protect that privacy. The will, however, is presented when it's presented to the probate court for an administration, does become a public document. And people often, less common now, would actually file a will with the probate court. And so here in Kent County Probate Court actually has thousands and thousands of people's wills on file. In that way, if somebody does pass away, they can present the certificate of death, and there's already the will on file with the probate court. We typically don't advise to file with the probate court. We just leave it an internal document. Part of the reason is, as that document changes, we don't want multiple copies floating out there that might be conflicting.
Okay. Another question we have here from the audience, Eric wants to know, can the trustee or trustees also be the beneficiary in a trust?
Absolutely. They can be, and in some cases they aren't. So in a typical living trust, meaning the grantors are alive, in a revocable trust, meaning the trust can be changed, the grantor could be the person who created the trust, the trustee who's managing the trust, for the benefit of themselves. We see that all the time. There are other cases in irrevocable trusts, asset protection trusts, where the trustee and the beneficiary are different people. But in a living revocable trust scenario, often the trustee is also the beneficiary.
Okay. And the next one, Brittany wants to know, in our current environment with COVID-19 and all the uncertainty out there, are you guys, Alice Law, are you guys doing telemeetings with new clients to discuss getting started? And if so, like, is there a fee for that initial session? How does that work?
Absolutely. We're doing a lot of this exact meeting. We've transferred from in-person initial consults to phone conferences, FaceTime, Zoom, whatever the person is most comfortable with. And our initial consults are absolutely free. And that's getting back to our promises. You're not gonna pay us a dime until you know exactly what you've signed on for and why. So, yeah, absolutely free consults. We're doing Zoom, we're doing FaceTime, we're doing phone calls, whatever somebody is most comfortable with.
Awesome. Now, another question that we got from Facebook. A lot of people have plans to have more kids. A lot of people have plans to buy more assets. A lot of people, hopefully are hoping to do better in the future. When you write an estate plan, do you have to pay the attorney to go back and make big changes every time you have a kid, every time you buy a house? How do changes work with these kind of living, breathing documents?
Yeah, great question. So on the front end, we try to build enough horsepower into a plan that it's adaptable. So we will define children, for example, as people biologically born to you or legally adopted by you. So if you husband and wife had 2 kids, for example, and they just wanted to evenly divide their estate to their children, and they had a 3rd child, we've already defined children as somebody biologically born to or legally adopted by. So they wouldn't need to come in and modify their plan. We also have built in alternate fiduciaries. So we might name a trustee, a husband and wife might start out as trustees, and a successor trustee is named. But we'll also name a couple successor trustees after that person, just in case they are incapacitated themselves or refuse to do it. So we try and build a lot of contingency planning in the original document. Therefore, every time somebody has a child, they don't have to run in and necessarily have their plan updated. However, there are those cases where there's a change in how the distribution schedule is going to go, or they want to change a fiduciary or somebody filling a role. The plan is adaptable enough where you don't have to modify the entire plan. You can take out a provision in one of the documents and swap it out. So it's typically very cost effective to make amendments as you go along.
Okay. And then question on, Brett would like to know, what's the general cost range for different types of documents? Or is it too custom to say? Yeah,
I mean, and sorry, Brett, I'm not trying to dodge the question. It's without knowing somebody's situation, it's very difficult to put a price on. It could be somewhere between $500 and $50,000, depending on the complexity and what they're looking to accomplish. But that's why we offer the free consult. We want to take the fear of cost off the table. Come in for the free consultation. We can lay out what somebody needs, and we can quote a price. We can tell you what the price is on a flat fee on the front end.
Well, thank God Zoom has a whiteboard function, because I don't think you guys would be able to deliver the same flavor without that. Last question I see so far, in case anyone else wants to comment any. Rhonda would like to know, are e-signatures legal for personal reps and or trustees for estate documents if they live out of state? So
there has been a recent loosening of the electronic notary and witness standards here in Michigan. It's a short-term loosening at this point. So within a couple of weeks, it's going to tighten back up. So e-signatures it's not quite like a real estate transaction where people are just clicking the DocuSign and they're going through transactions that way. There are higher standards for the witnesses and notaries. So while it's been loosened here in Michigan for the short term, I wouldn't go as far to say that e-signatures are legal. And again, each state, it's going to have its own set of guidelines. So if somebody is filling a role as whether it's a personal rep or trustee out of state, we'd want to talk and get more fact specific on that.
Awesome. Well, Jordan, I just want to say a huge thank you for taking the time to share all of your knowledge with us today. I know one of the reasons I was most excited to do this chat with you is that I know a lot of us at home are with our significant others, or with our parents, or with our spouses. And I think now is a great time to start communicating with the people that we love about important issues like estate plans. Plus, we have the time if we're physically sitting next to them with no chance of escape.
Yeah, absolutely. You know, we're working remote, but we're still open. We can still meet, virtually meet with people, meet and design an estate plan through the comfort of your own home in your pajamas. We can get that done. Strongly encourage it, especially now. We're having a lot of people who are recognizing the reality of incapacity and the reality of the need for these documents. And we just want to be a resource, even now, even if it's a little bit, different than it was 2 months ago. We can still get these documents done.
Absolutely, and I think everyone in here feels kind of the same. I see a lot of realtors who have tuned into the call, and there's a lot of uncertainty out there in the market. There's a lot of uncertainty when it comes to the real estate market, the economy, health, things like that. So anything like this that can give families a little bit more assurance, just knowing that there's a plan, is a huge asset. So once again, from everyone at Treadstone Funding and Alice Law, we want to say a huge thanks for tuning in. This webinar will be recorded and will be live on both Alice Law's Facebook, Treadstone's Facebook, and will eventually be recorded in our library of series. And for anyone that needs a little extra help or information on the current mortgage market, 15 and 30-year interest rates are still incredibly low. They're in the bottom 1% of the lowest that they've ever been. So if anyone out there needs to refinance or has friends that need to, call your favorite Treadstone lender, and we would love to help. Thanks, everybody.
Thanks, Matt.